All right. Good afternoon, everybody. Thank you for joining us today. My name is Josh Green, and I'm the director of ICAP, the Innovation Commercialization Assistance Program. We're a program of George Mason University and the Virginia SBDC. We're also very fortunate to receive funding from VIPC as well as a number of other state organizations. The focus of our program is to assist early stage technology companies in the Commonwealth of Virginia. And that can range from private companies, faculty members, graduate students, postdocs, anybody who's interested in moving a technology venture forward. We are part of George Mason University and the Virginia SBDC. And what that does is allow us to operate statewide. So we work with folks from as far southwest as you can get, as well as far south, north, and everything in between. We have a team of over 20 mentors from a multitude of different backgrounds and experiences to be able to help work with companies one-on-one to move them forward and be able to offer the assistance to get them from where they are to where they want to be. We've been around for 6 years, and we've worked with, over that time, over 1,250 companies that have gone on to raise a little over $145 million in capital. So we're really excited about the work that they've done. One of the things that we do is hold events like this to make sure that folks who are interested in getting their work into the world are able to get the resources that they need. I'm going to pass it over to our moderator for today, Sean Mallon from VIPC, to introduce himself and take it from there.
Josh, looks like that Sean has lost a connection or something. I don't see him.
All right. Well, we'll roll with the punches then. And Hina, since you are part of VIPC, would you mind sharing a little bit about the organization and then what you specifically do within CCF, or talk about CCF as a program?
Absolutely. So I think maybe some of you already know about this, and those who don't, Virginia Innovation Partnership Corporation is an agency based in Virginia. We are affiliated to state and primary conducive mechanism to advance innovation and entrepreneurship. So under VIPC umbrella, we have different programs, and program specific to which Sean and I sit at our Commonwealth Commercialization Fund. So this is a perfect series, to kind of navigate through whole commercialization process and where as a funding mechanism we can come in. So this is a grant program to advance research to market, fill in the gaps where it's needed, like prototype development, de-risking the technology, doing your customer discovery. So when you are in all that phase, be you are a researcher or you are a private company, this program, grant funding program, can be very, very instrumental in filling that gap. So that's overall, CCF and VIPC. With that, I think I will hand over to Sean. He is back online.
Perfect. Well, thank you, Hina, for filling the gap while Sean had to get reconnected. Sean, if you want to introduce yourself before I talk about today, and then I'll pass it over to you for good.
Thank you, and my apologies. When you're in a strange place, you can never exactly count on broadband. Yeah. So, hi everybody. It's good to see some familiar faces on the in the audience as well. Sean Mallon. I'm a vice president for commercialization at the Virginia Innovation Partnership Corporation. Hina's colleague. She and I work together every day. So our program is a grant program, but we also within VIPC have an equity investment program as well. I came in partway through Hina's remarks, so I don't want to restate what she said, but we can certainly get into more of that with during the Q&A, should anyone like to do that. Go ahead, Josh.
All right. Thanks, Sean. So the goal for today in the series that we have on university commercialization is really to help provide a baseline of understanding for what it takes to get work from the lab to the market, and the resources that are there to be able to assist throughout that process. The Tech Transfer Office and the folks today are primarily focused within Tech Transfer is about making sure that the process is followed to help make sure that it is effectively getting and correctly transitioned from within the university context out into the world. There are a lot of benefits, and I know that Sean has some particular questions that will help share what those benefits are, and we'll have an opportunity for everyone to be able to ask questions at the end. Feel free to include in the chat any of your questions, and we'll make sure that we get to them. But for now, we'll have just the panel go, and we'll keep everybody muted until the end. I'm looking forward to the panel. I know there's been a lot of great information that's going to be put together and shared. So, Sean, I'll pass it to you to get us started.
Yeah, thank you so much. Can I just clarify whether our other panelists have introduced themselves already?
Not yet. Sorry, that's what I thought you were going to kick us off with.
All right, so why don't we go ahead and go down the line, starting with Rich. Just a minute for each of you, who you are, what you do.
Hello, everyone. My name is Rich Chilla. I'm the Executive Director at the Licensing and Venture Group at the University of Virginia. I've been doing academic tech transfer for about the last 15 years, and I spent my first 20 years in industry as a research engineer.
Okay, great. Grant.
Hi, I'm Grant Brewer. I'm the Executive Director of the license operation here at Virginia Tech. I've been doing tech transfer off and on for the last 20 years, including some startup and incubator work. Before that, I spent about 10 years in pharma and medical device industry.
Okay, lovely, thank you. David Grossman.
Oh, hi. So I'm the Senior Director of Technology Transfer and Industry Collaboration at George Mason University. I was also an engineer, a practicing patent attorney, and adjunct professor of patent law, each for about 20 years with some overlap. Additionally, I've been part of multiple startup companies.
Thank you, David. Hina, you had a few words earlier. Is there something that you wanted to say that you forgot to say or didn't say in your intro?
Yes, I focused on VIPC, but for me, currently I'm the Director for University Programs at Virginia Innovation Partnership Corporation. But prior to that, I spent 10 years in technology commercialization space at George Mason University, along with David with a few months overlap. And prior to that, my experience is biomedical research science, as well as a startup company.
Okay, awesome. Well, thank you guys for that. And again, for the audience, we're gonna kind of work our way through our kind of planned remarks until about 20 minutes till 2, and then we'll open it up for Q&A. So if you have questions, you can drop them into the chat. Josh will be curating those questions for us as we wrap up. But let's kick it off with the kind of the background for tech transfer. I think that the folks on today and folks that will be watching this in the future may not know much about that. So Rich, I'm going to turn to you to kind of kick us off with kind of the history of tech transfer, why universities provide these services, the goals and things like that. And as you wrap up, maybe others can chime in as well with thoughts that they have.
Yeah, thanks very much, Sean. So I'm going to start where it all starts. Where it all really starts is with research. And the federal government spends about $160 billion a year at either universities or federal laboratories on basic research. And they do this because they want to improve the competitiveness of U.S. industry. They want to improve health for American citizens and to grow prosperity for U.S. citizens. So that's basically why they do it. But in order for that research to actually have those benefits, it somehow has to get transferred to the public. And the way that happens is through companies being able to commercialize technology. So really, most tech transfer offices, the way they exist today, it's all since 1980, and that's because of something called the Bayh-Dole Act. And I won't go into all the details, but before the Bayh-Dole Act in 1980, if a university was developing something for based on a federal grant, any intellectual property, any inventions that were created, they belong to the federal government. And the only way that a private company could get access to those inventions was to request a license from the U.S. government, from the funding agency. You can imagine that probably wasn't super efficient, and so very few things got directly commercialized out of U.S. Research. So in 1980, the Bayh-Dole Act occurred, and what the Bayh-Dole Act, it had several provisions, but the most important provision was it allowed universities or federal labs to claim title to inventions that were created by federal research, and in exchange for that, the university or whoever claimed title had to agree to work to try to make get the technology commercialized by working with industry and having license agreements to transfer the technology to industry. And that's sort of the commitment. And that's why most of our offices exist. It's to fulfill that part of the bargain. And so it's actually, Bayh-Dole Act is actually considered by many as one of the most effective pieces of legislation passed in recent history. Just a few facts and figures. Since from 1996 up to the present, economists have computed that technology commercialized out of universities has contributed more than $1 trillion to gross domestic product. There are more than 17,000 startup companies created since '96, and maybe what we're most aware, there's through public-private partnerships, 200 drugs and vaccines have come through Bayh-Dole from 1980. Before 1980, there was zero. So it's really been it's been a success economically and for the public. So that's why we exist. We exist to try to disseminate the benefits of the basic research to the public, and that's why we're all here.
Awesome, thank you, Rich. And did any others on the panel want to have some specific thoughts about kind of the whys and why it's important that you'd like to contribute?
Well, I would just say that the federal government has been experimenting with how to do this since the 1800s. And they have not been very successful. They've been successful setting up new agencies for research to try to provide a public benefit, but they haven't been very good at getting the benefit out to the public. So,
okay. And presumably, it's up to each university then to fund and to create a tech transfer office then, or a tech transfer function that is capability appropriate and size appropriate for that institution. Is that right? There's no federal government funding to support tech transfer per se.
In general, no. There's some recent legislation in the CHIPS and Science Act, which can be used to potentially fund some aspects of technology transfer. But in general, you're correct, Sean. It's if you will, it's an unfunded mandate. And most of the money that runs our offices comes from the university budgets themselves, but potentially supplemented by a little bit of the income that might come in through licensing royalties. But not to give away the goodies, but it should be noted that most university offices, more than 80%, operate at a deficit, and so it's not true that universities are some huge profit center or tech transfer offices are a huge profit center for the university.
Well, that leads us well into our for the audience, the way we decided to construct this discussion was around misconceptions to begin with. So the misconception number one, and Dave.
okay, misconception number one: universities are greedy. Is that what we're talking about?
Universities are greedy. So take it away, David.
Well, let me just state that our goal really is to maximize the impact of the publicly funded research. It's really not to maximize profit. Look, we all know, or most of us in the business know, that lucrative inventions are exceedingly rare. And because of that, most tech transfer offices, as Rich already said, right, are actually cost centers. We don't make enough in licensing revenue to cover our operating expenses. I can count on one hand the number of tech transfer offices that I'm aware of that operate in the black. I'm guessing that there's a few more based on statistics I've seen, but I don't know who they are. I would say that our office, if it has any other goal besides the impact, is has an economic development bent, and to say that we're really here to help startup companies successfully commercialize university technologies. I think that kind of discussion may come up a little bit later. Also, the other things that we do with the funding that we get in our university comes from our provost office. Is, we're part of the Mason enterprise system. So, we try to work with startups to give them resources to be successful. We try to refer them to potential funding sources, training, mentors. We also, really, we're just trying to help our startup companies for, another example is we try to help them keep their cash up front when they're really young. We will front patent expenses that could be, up to like tens of thousands of dollars per patent. We'll often delay royalties, and we'll do all this right until the company can become revenue positive. And this is not the kind of deal that you will get from anyone else. I mean, the university is spending money that it's not bringing in to basically help get these technologies out into the public. Our hope is that by doing this, we'll be helping build the local economy and trying to make an impact on society by getting these technologies out there that I think otherwise the majority of them would never make it into the marketplace.
David, thank you. What is in the spirit of helping, and that's certainly been my experience as well, can you just maybe describe how your office and others can chime in as well, how you first come into contact with university faculty and researchers and others who may or may not.
I'm going to answer the question I think you asked because you're having a lot of
services over time.
Yeah, I'm going to answer the question I think you're asking because you're having a lot of distortion.
Go ahead.
But the
I see.
Getting in touch with contacting the faculty is really one of our challenges in our office. And we do it over time. We become friends with a lot of the faculty. We have lots of lunches. We talk about their research, sometimes years before it gets to the point where it's ready to be commercialized. We give lots of talks. And honestly, a lot of our faculty come to us through referrals from other faculty. And we do some deep dives. At Mason, we happen to be lucky that on the biosciences, we have a building where we have a lot of research that's being done. And we go down there once a week and we walk from office to office and talk with everybody. And the idea is to have all these conversations, sometimes years before they're ready to go down the commercialization route.
Thank you. And my apologies to you and everybody else for questionable connectivity. I'm still trying on my big laptop, but it's not working. To misconception number 2, if we need to circle back to any of these things, we can. So Grant, I'm going to hand this one to you. And the misconception is that tech transfer offices prefer to license to big corporations that are already going concerns. They prefer to do that than to license to a university spin out. Can you maybe clarify that one and unpack it for us a little bit too?
Sure, yeah. So thanks for the opportunity to comment on this. And I think as most things go in the tech transfer world, the answer is always it depends. But I think as a general rule, this is a misconception. often and generally would prefer to license our technologies to a local faculty-driven startup when possible. Having said that, I just want to kind of circle back to what David said, and I think the goal is similar for most of us, and that goal is impact, right? We want the research to have the broadest possible impact. And there are certainly times when a large going company would have all the resources and expertise to have the best chance at achieving that impact. But even in a case like that, we would almost never, or I think I could say never, make a decision like that without a great deal of discussion and buy-in from our faculty. So I think in reality, most university technologies need a startup to mature the research into something that is interesting to a large corporation. There's very rarely do we get an invention disclosure that's ready to be licensed by a massive, multinational corporation. So the startups do the work of, product development, beta testing, all the commercial development work that you would do in a company that you wouldn't do in a research lab. That helps to, alleviate some of the risks concerns that you would see if you wanted to license the technology to a large company. So, in summary, I would say it often makes sense to go with a local startup. We prefer to go with a local startup, a faculty-driven startup, especially. I think the comment was made earlier that we give terms to local startups that we wouldn't give to, large corporations that aren't going to, as directly benefit the local community. And we do it all in concert and conversation with the inventors and the stakeholders.
Thanks, Grant. Your comments really kind of hit a chord with me too. That the outside entity that would want to just license a patent is probably going to just look like someone that likes to have a lot of patents in their portfolio, right? They might have a lot of money to put forward, but a patent is really just a piece of paper. It doesn't, you need to have the insights and wisdoms of the inventor or the inventors.
Yeah.
There needs to be some kind of actionable product development or revenue stream or something like that. And, having something that says you have a claim on this little piece of technology does not resonate that much with, in big companies, small companies, and otherwise. You really need those human vehicles that act as the translation of getting it into something that can actually be discussed and understood as an opportunity rather than just as something that the U.S. Patent and Trademark Office gave you a claim on. Would others like to kind of comment around that particular theme?
Yeah, if you don't mind, Sean, I can just add, what you said is exactly correct, but also regardless of whether one of our offices does a license with a large company or a startup company, in order to see that that the technology is actively being developed for a commercial product, all of our licenses have some, we call them diligence milestones, but some objective criteria that compels the licensee, the company working on it, to be investing in it to try and develop a product. And if they don't, then they have to give the license back so that we could potentially give the technology to someone else who wants to advance it. So.
Right, because presumably someone that's just kind of a patent warehouse doesn't fulfill your requirement of getting this technology out into the world.
That's right.
No.
Great. Okay, Hina, you're up next. The misconception number 3: tech transfer offices don't know how to structure entrepreneur-friendly licenses. I hope everyone on the panel has things to say about this, but we're going to kick it off with you, Hina.
Yes, that I would say has been a real misconception all around tech transfer. But I think Grant already touched upon some of the points that are crucial as a tech transfer professional, that we have involvement from faculty members. That's the key to the success, because they have all the know-how behind the IP as well as the technology. So getting them on board is so important. So with that in mind, of course, we want to work with the faculty and we want to work with the entrepreneurs. So making those connections and making it as friendly as possible is the goal for the tech transfer. And I think I'm sure my colleagues will agree, because I think we all carry the similar philosophy that if our entrepreneurs or startup company, if they succeed, we succeed. Because if they are going on the path to product development, fundraising, and building that product and ultimately put in the market, then only that revenue will come back to university and eventually to the faculty. So being, burdening them upfront with a lot of, payments or, those kind of costs doesn't serve anyone any purposes. And so most universities would structure their license with the startup company where they have deferred all the costs, at the later end when they reach certain milestones or when they reach certain revenue, things like that, so that they can preserve cash and, while they are fundraising, ramping up their operations. But yes, also with that, I would say that, again, it also ties up with one of the points Rich and David discussed earlier, that tech transfer offices are kind of, funded by university. And sometimes it is a little bit of, we also act like an entrepreneur, where we also have to have our own little bit of fundraising. And that comes from, are we able to get patent reimbursement, for example? So that those costs will be up there, but not usually upfront. And even if in some scenario, very rarely, even if some of the upfront payments are asked for, it comes down to the technology. Because if it's a therapeutic license, for example, then yes, it is possible that we can defer all the payments because, costs are high to do the R&D. But for example, we talk about software. Once the code is out from the hand, we do not know that whether there will be kind of a reverse engineering, whether they will do another, derive the code and, use it or not use it. So in those cases, it makes sense for us to ask for upfront payment. And probably sometimes that gets perceived as, oh, university are greedy and they are asking us so much, they are not entrepreneur friendly. So it's a kind of a fine balance. But in general, I would say, as a tech transfer, I'm sure I can speak for my colleague too, that we are like, entrepreneur, we do our best to be entrepreneur friendly licenses.
I'd like to make a little comment that we haven't touched upon that Hina's kind of reminding me of, and that's equity. Sometimes when the companies, because we're providing so much upfront, sometimes we'll ask for some equity as sort of a trade-off. Then, that puts out any returns for many, many years, right, until there's an exit event. But it certainly helps. And then everybody gets money at the same time. And then that leads to one more thing, which are VCs, right? Because that's what everybody wants to get to. They want to have a startup that's eventually going to be get funding. And so we also work on trying to come up with terms that we think, especially with equity, that'll be friendly to VCs. And we spend a lot of effort trying to make sure that that's the case.
That's a really good point, David, and reminding me that it really goes, a deal can fall anywhere on a spectrum between, whatever remuneration to the university, the tech transfer office could be upfront, or it could be all the way on the back end when everyone else makes money, or a combination of in the middle, right? And that's probably some combination of in the middle is where it happens most times. Not specifically part of this misconception, but I think maybe this is a good place to kind of insert it and kind of a jump ball on this one. So the Patent and Trademark Office patents certain things and it doesn't agree to patent certain other things. And the non-agree to patent generally falls in the software world. Can you guys, maybe David, starting with you, talk a little bit about how software is treated by the PTO and how tech transfer thinks about software, where it's not really IP in the classic sense, but proprietary nonetheless?
Yeah, so the first thing we do when we get a disclosure, and so software goes through the same analysis, we try to decide where the value is, right? Is there a commercial value? Can we protect the intellectual property? Is what's being disclosed actually really work? I mean, we're looking for like this nice little intersection. So on the IP side of whether it's protectable, and we're talking about patents, the patent office has come down pretty hard on software that can just be run as like an app or a business method on general purpose computers. That doesn't mean that software is not patentable. Software, if it's basically coming up with a technical solution to a technical problem, especially if there's some kind of specialized hardware involved, it generally will be patentable. But if that's not it, if it's just a pure mathematical algorithm or a business method, it probably won't be. And so in those cases, we'll look at other ways of trying to protect the software. And sometimes the best way to do it is with some kind of a non-commercial open source license, and allow a company to form around that. And other times it's trying to keep it a trade secret. But I think someone mentioned earlier that, there's always reverse engineering. So, so there is a limit to what can be protected. And when we license out the software, we're really hoping that there's something magic in there that's not that easy for someone else to figure out how to do. And when you're coming up with a technical solution to a technical problem, that often is the case.
If I could just add to what you said, David, is sometimes there's a misconception that a researcher feels they have to have something that's patentable in order to work with our office. And that's not true at all. Actually, if you have any type of innovation, even if it's potentially not patentable, we'd like to have a conversation with you, because our office works to help, besides licensing out patents, we work on licensing out university curriculums, sometimes websites, sometimes apps, sometimes pieces of software. I've even licensed out mechanical designs for things that are not covered on my patent. So we can be pretty creative in helping to get your innovations out in the hands of companies. It just doesn't have to be a patent.
Thank you, Rich. And I'm going to stay with you, Rich, as we transition to fact or fiction jump ball section.
Okay.
And hand you the first one, which is, so for those of you, we're all kind of in Virginia right now, but people say, well, other states are much more generous. So the question is, or the fact or fiction statement is, Stanford and MIT offer cost-free licenses to faculty founders. True, fact or fiction, Rich?
That would be fiction. Would be a fiction. The terms that Stanford and MIT offer to their founders are very, very similar to what the schools, to any of us, what we're going to offer to our founders. So that's not true. Sometimes the way I think that misconception happens, Sean, is the Bay Area and Boston area are very, very good places to found companies. There's lots of resources in those cities, but that has nothing to do with the terms they're getting from the university. They're getting fairly similar terms to what we provide.
Thank you. Anybody else want to add anything to that?
Yeah, I would add that there is a simple Google search could probably take you to a term sheet, and now it's listed as being specific to life science related startups, but a lot of those universities got together and came up with a term sheet that they felt was fair I think Stanford and MIT both might be on that list. So if you want to look at, industry standard terms that have been agreed upon by a lot of the larger academic research institutions, you can find that pretty quickly in one document that will tell you what terms they suggest asking and a good bit about their rationale for why they're requesting that.
It's a good point, Grant. We've signed on to that as well.
Yeah, it's a good, and it's as Rich said, it's I would say it's on par with ours, if not even a little more onerous than a lot of the ones we do. Yeah.
And does that serve as a starting point for your discussions, or do you basically live with that agreement?
I would say it's a starting point, and it's really it was designed predominantly around the therapeutic area of life science. And so some of the terms may not apply to engineering innovation or medical device or things, but it's still, it's a nice starting point.
I think your milestones and things may be different if you got into a different industry, but conceptually the types of compensation that are asked for might not be any different. And what you see is they ask for equity in lieu of cash to defer expenses, and then some small share of future commercial success in the form of a royalty. So
I would also add that the term sheets, and hopefully people know what term sheets are. It's just sort of a short form of figuring out what all the terms are going to be before writing a big license, are always negotiable because every situation is unique. And it deals with our faculty, and it deals with the startup or company that's going to do the licensing. So the term sheets normally list all of the different points in which we might negotiate, and we usually end up striking out a good number of terms. And the terms we're most interested in are the diligence terms, right? Because we want to make sure there's going to be an impact, and we have a tendency to let the startups show us their idea of how they're going to commercialize it, the technology, and what kind of milestones they think that they're going to meet. And so we don't sit there and try to dictate what those diligence milestones are going to be. And then that's the guideline by which we can judge whether the technology is being moved. And one last comment about the diligence is we also are very friendly to making amendments along the way. Because people often set up milestones very optimistically. Entrepreneurs are very optimistic. And so, we're always open to like this continuous conversation and adjusting milestones as they go ahead, as long as we see that the technology is moving.
Yeah, in our office, if you want to license the technology, the first thing we're going to ask you to do is provide us some type of plan. Doesn't have to be a 100-page business plan. As a matter of fact, we've got some questions that we can give you that, answering those questions will provide us most of the information we need. But the point is, you don't want to start negotiating terms that aren't based on any type of objective plans. And the same goes for much of the compensation. You have to establish the plan and the at least perceived reality in that moment, so that you can try to do some type of objective math and planning to get on a document that both parties agree works for the technology and the company. And then as reality, comes into play, and the things that you anticipated don't turn out the way you'd hoped, we amend the licenses. And then when investors come in and have things they want to see in the license, we amend it again. So, it's all a very fluid process. And, one thing I try to let faculty and startup and any kind of entrepreneur in the area know is that there's no situation where signing this license agreement is going to bankrupt you or chase you around for the rest of your life. If things don't work out, we'll terminate the license agreement. We just ask that people make their best efforts and give us a good plan on how to move forward. But I do sense there's sometimes anxiety when you talk to people about signing a license agreement. And, we do our best to let them know that, it's okay if it fails. It's not ideal for anybody, of course, but no one's going to chase you down with collections, and it's not going to be the kind of a financial devastation for you if your startup doesn't go the way you wanted it to.
Yeah, that's a good point, because on all of our agreements, we always allow the startup to terminate the
Yeah.
license for any reason
At 30 days. Yeah.
at any time.
That's right.
And it's the preferred way, because
Yeah.
if they've decided that they're going the wrong way, let us find someone else and
That's
get
right. Yeah.
technology out there.
Well, and I think this thank you guys, and this kind of is a reminder too, that treat the technology transfer and your point of contact there in particular almost like your personal attorney, right? There's no one's out to get you. If there's bad news that's coming down the pike, they should be one of the first ones to know, right? Not because they're going to tighten the screws on you. On the contrary, they want to be there to be flexible and to work with you to work through different things. And particularly as more and more as tech transfer offices are also providing commercialization assistance as well, right? It's not a one and done transaction. It's an ongoing relationship that I think can be built.
Can I just add one more
Sure.
thing to that? And we're talking about financials and universities and greed and all of these things. I think it's really important to recognize that in my case, half of every dollar that I take in is going to the inventors. So I see myself not so much earning money for, the institution, as I see myself making sure that the inventors are rewarded and sharing the success and any kind of commercial success that comes from their ideas. If you design something in your lab and Pfizer makes a few $1 billion on that idea, I'm more concerned with that inventor buying the Lamborghini that he deserves than I am putting, a big check into the bank account of Virginia Tech. So I don't mean to rank the institution versus the inventor, but I do want to make it clear that I think all of us see ourselves as doing something for the inventors, representing the inventors and helping them to get looked out for and to be rewarded when their ideas have impact.
That's a great point. We've covered our other kind of toss-up fact or fictions indirectly through answers to other questions. So I'm going to propose that we move into the Q&A section. It's 1:45. And Josh, hopefully you have been able to queue up a few questions for us.
No questions have come in via chat, so I'll open it up. If somebody wants to ask a question, feel free to either type it in the chat or you can unmute yourself.
And one thing that I'll say is, until someone does unmute themselves or type into the chat too, is this is the first of 3 sessions. Josh may have reviewed that. Same time, same place next week. We'll be talking more about specific commercialization options as a founder, as a university researcher. And then 2 weeks from now, we'll be talking about some of the funding programs that are available to university-based spin-outs as well.
So while we wait for the questions, I want to add one thing. I think the fact and fiction you just proposed, Sean, you might have heard somewhere, because I have heard the similar thing recently, that West Coast has been equity only licenses. And that I think I did a little bit of research. I spoke with my colleagues on West Coast, and as Rich and my colleague told, that no, it's a fiction. They don't do equity only licenses, and when they do it, there is a very, very strong reason behind it, that the technology is such that it is going to be hard for anyone, be it West Coast or East Coast tech transfer. It's the technology that is going to be maybe integrated in a larger component, and it's going to be very hard to decentralize it to find out, okay, this is a portion of the technology that earned this dollar. And at that time, they might do it in equity for only license, or also because they already have come with an investors lined up with the startup, they have exit plans. when they see all the circumstances, probably they do the equity licenses. But somehow, for some reason, that has spread like rumors around the areas that, okay, they do only equity license, they don't charge anything upfront. Whereas the East Coast universities have been doing that. It suddenly became East Coast versus West Coast. So it was interesting that you asked that question.
But it sounds like, go ahead.
I was just going to say, I will note that, figuring out an equity position in a startup is, I think, much more straightforward than figuring out a royalty due on some product 10 years from now, when your technology could be 1/10 of the component. Maybe your technology is the battery in a smartphone, and yet, you agree to a 1% royalty, and what is that royalty on? The smartphone, or, so I think, royalties can get very difficult to, create in a way that's not polluting downstream. Whereas with equity, you can put some kind of value on the research and the IP that you're putting into the company, and take that as a ratio of what the company could reasonably worth at that moment, and agree on, look, treat me like a founder that's putting $1 million into your company, because it would cost you at least $1 million to do this research on your own. But, and for that reason, there may be times when royalty agreements, either they don't look like they normally would, meaning a percentage of net sales, or you just pile a little more on the equity to avoid that downstream pollution. So I wouldn't say that it's all or the other, good or bad, to not have royalty in every deal. I can think of a lot of times when it might be easier to find another, way of being compensated.
Yeah, thanks. Sorry, was there something else? I had a slightly different thing, but if someone would like to add on to that.
No, I was just going to say, once you're done, Sean, we have a question.
Okay. And is it Robert Brooks' question?
No, Jerry Cronin has a question.
Oh, Jerry Cronin. Let's start with Jerry, and then I saw Rob text something in too that I think we might be able to address.
Jerry. Hi, folks. Good to be here and see some familiar faces. Question. One of the things I'm interested in when I'm talking with research faculty is the impact on future grants in that research area that might have an impact on now a startup that they're an equity holder in. How do you guys deal with that?
So
repeat that. Sorry.
Okay. That research faculty comes up with some IP. Great. You spin out a startup.
Right.
They're an equity participant in it along with the university. Now they're going after grants in the same domain that are going to be applicable to this company they've now started. How are you guys deconflicting that?
Right. So we have at Virginia Tech, we have a conflict of interest committee and department that looks into these issues. It's under the same umbrella as kind of your research integrity. And the way that in short, the way that's handled is by creating oversight, so that your PI on the research grant, it doesn't stand to directly benefit financially from the results of the research, as they would affect his startup company. So if you were, say you invented something in your lab, you licensed it to your startup, and so we'll call your startup Nuco. Nuco has a license to the technology, and then more directly, you might just get an SBIR or an STTR that includes Nuco into your lab. You would bring in another PI that would have some oversight on the process. But those grants are set up to do exactly that, to help develop the technology in the startup. So we don't want to cut off a faculty member from other funding sources that are aimed at doing exactly what that faculty member is trying to do. We just have to build some checks and balances into the process.
And in our office, we actually sit on those committees because we're the ones who can explain to everybody else what the startup is about.
Yeah, and same here. Yeah.
The other thing I'll add, Jerry, is that once a technology is licensed to a company, to a certain extent, there's a little bit of a bifurcation in the interest. The company is interested in creating a product out of the technology, but the professors are interested in advancing that research further and doing more of a pure research. So it's not necessarily in conflict. They both have different goals at that time when they're writing for grants. They're trying to advance the basic science further, while the company should be moving towards a commercial outcome or a product.
Right.
Yeah.
And there are situations where the professor might not have any equity or financial stake in that startup.
Yeah.
And
Yeah,
there's
that's the easy case. I'm
Yeah.
wondering more about the case where there's an equity participation by
Yeah.
the research faculty with the spin-out the spin-out company.
Well, Jerry, from my perspective at VIPC, where we have a grant program that supports both higher ed researchers when they're still within the walls of the university, and then moves along with them, or at least with their new entity, their new co, that we look, we really look to the faculty members and the tech. We always check in with the tech transfer offices just to make sure everything is copacetic. But I think I'll agreeing with Rich, which is, we see some, and we'll get into this kind of, I think, in the program next week in terms of looking at different commercialization pathways, right? Whether faculty member is doing NUCO on their own, whether they're basically a part-time CTO being accompanied by a full-time team of commercialization people, or whether they're just, a consultant to NUCO or something along those lines. I think would be, those would be slightly different pathways that would probably get different look-sees. But SBIR is certainly private sector. The CCF private sector is, we would go all in on that, even if there was an equity participation. And we would, in fact, expect and be quite surprised not to see an equity participation on behalf of the faculty member, as well as, in the case of an equity licensing deal, the university as well.
Thanks.
I would also just add one other point that I was thinking about when you first asked the question, which turned out to be a little bit off point, but we always reserve rights to the technologies to do continued research. That's very important to the university, especially sometimes if a technology gets licensed to a company of which the researcher isn't part. We never want to have a situation where the researcher can't continue to do research.
Right.
Now, Sean, to get to Robert Brooks' question, is there any support for spinning out companies or for landing spots for departing postdocs?
Yeah, so this just it opens up kind of a whole new thing, and I think we can talk about it more in next week's session as well. But it speaks to the fact that not every hugely productive research faculty member is able or comfortable, even wants to wear the entrepreneur's hat. But they may have students, graduate students, postdocs in their labs who may be very happy to kind of take the baton, the commercialization baton, and run with it. And in the few minutes we have left, if we can maybe talk about any distinctions that tech transfer offices make between a faculty-owned IP, or 100% faculty-owned IP, and IP that has both, potentially student as co-inventors as well, if that's treated any differently from in the tech transfer world.
I would say it is, because it takes away the university's ability to unilaterally license the technology exclusively, which creates, complications and issues with moving forward. So if you have a situation where you have a faculty member and two, say, undergrads, then invent something, if you were to file a patent, you'd have, basically three assignees: the two undergraduate students and the institution. We've tried to do different things where the parties who weren't obligated to assign made a decision to assign to Virginia Tech, but in many cases, people have changed their minds later. It's created some heartburn, I'd say. So there's no easy answer there, but it definitely changes things.
But if someone is a PhD student that's actually on a university payroll,
Then they're obligated to assign under the IP policy, right?
Just the same as the faculty member would.
That's
So
right.
that makes
That's
for
right.
a cleaner invention disclosures when
That's
you
right.
have grad students or postdocs.
So it's also, the reason that's clean, right, is because the graduate student is probably doing funded research and they're using significant university resources. It could also be the case with some undergraduates that they also are using what we call significant university resources. And there's some state laws that sort of, policies that sort of guide us in what we can do in those situations. The one thing that we don't do, right, is try to claim any ownership on work that a student did that's just part of their education.
That's right.
You know, that you know, there's a clear line, right? And unless they've been funded, we won't go, you know, we'll give them plenty of free advice, but it's really their technology.
In an engineering school, I think what happens, especially later in their academic career, they start, you know, having to invent something as part of, say, their senior, you know, senior graduating credits, and they'll work with a faculty member to invent something in the course of their, you know, degree seeking course, credit seeking course, and you know they'll get very excited about what they came up with, and then that's when we have situations where we have to, like I said, we're still working it out, but you know, we've had faculty say the students want to assign to Virginia Tech because they think this is worth patenting and licensing, which but you know, it's as I said, it can get complicated when things change down the road, ideas or opinions change. So
the only thing I'll add on to Robert's direct question is we love when postdocs want to take out something into a startup. That's great. So,
we're actually setting up a program for entrepreneurial based postdocs with the goal of helping to fund a postdoc that's going to work in a lab and then go start a company, and have the work they do in the lab be, you know, company creation focused.
agreed.
I would say that to kind of continue on that, definitely please join the third session of this series, because that will cover a lot more on this question, how to kind of create programs to give a soft landing for the postdocs and the funding opportunity for them.
Number 2 and number 3, don't be there. Thank you to the panel very, very much. This has been interesting for me, and hopefully it's been interesting to our audience as well. Josh, did you have any parting words?
Yeah, I wanted to, in addition to thanking the panel, really thank you, Sean, for moderating. Appreciate everybody joining us. The goal is to help make sure that you understand the value of the Tech Transfer Office for this session, and to please make sure that you're reaching out to them early and often to make sure that you are on their radar. As Sean mentioned, we do have this same time next week and the following week 2 different sessions. And everybody who is in attendance today is already registered for those, and I'll send out a little follow-up information on that. But thank you very much for joining us, and we'll look forward to hopefully seeing you next week and the week after.
Thanks, everybody.
Thanks, everyone.
Thanks, everybody. Thank you.
Thank you.